We're speaking to Senior Advocate Nizam Pasha, who was the counsel for AIMIM leader Asaduddin Owaisi in the Waqf matter. Sir, in the morning when the judgment was pronounced, the reactions from the petitioners, the political parties were regarding the positives that the court has made certain observations, the court has issued stay on certain provisions, but by evening we saw very different reactions coming in. What is your read? How was your response to the pronouncement of the verdict and reading the judgment?
See, as a counsel for the petitioner, I am naturally quite disappointed with the judgment of the court because most of the relief that we had asked for, we have not been given at the interim stage. And now we look to the final adjudication of this matter on an early date so that these issues can be, the constitutional validity of the amending provisions can be decided once and for all. And the provisions which we believe are unconstitutional can be struck down by the Honorable Supreme Court.
Sir, could you tell us a little bit about how your client has responded to how they've reacted to the judgment before and after reading the verdict?
See, I would let my client speak for himself, but I think his reaction, as well as mine, has been consistent because we heard the order that was pronounced by the court. And while I was a little surprised by how there were people who, without understanding what the court was holding, went into either some kind of uncalled for celebration or, on the other hand, uncalled for criticism, depending on which side you were on. But I felt that the portions of the order, the directions which were read out in court, made it very clear what the court had held. And my position and my clients also, I believe, has not changed from when we heard the order that the court pronounced and after reading the judgment, because, like I said, it was clear all along what the court had held. And as far as the petitioners are concerned, it left much to be desired, and we now look forward to the final adjudication.
If I may ask, sir, the Jamiat ulema-e-hind, Maulana Madani has issued a statement where he said that it may lead to a lot of problems, especially when it comes to the court's comments in specific paragraphs about the Waqf by user issue. Especially since there are more than 1 lakh Waqf properties which are currently Waqf by user and may or may not be registered. How do you see this matter as a matter of concern?
See, the observations of the court, I'm not so concerned by, because obviously, in terms of the law as well as this judgment, these observations are only for purposes of prima facie adjudication. So they have no bearing on the final outcome of the litigation. And once the matter is heard finally, we are able to convince the court that these provisions are in fact unconstitutional, these observations will not stand in our way. So it's not the observations made by the court that I'm concerned about, but it's the fact that, like you mentioned, that there are lakhs of unregistered Waqfs in the country. And today because they don't have protection under the Waqf Act anymore, so their position becomes very vulnerable, and that's an area of particular concern. And in terms of the reasoning of the court, because it's just an interim order, as a lawyer, I don't find that reasoning convincing, because they just say that for the last 203 years, there's been a provision for registration. So if you should have registered by now. And if you haven't, then we don't see why not being allowed to register anymore at this, after so many years of opportunities is unconstitutional. There, I feel what is fundamentally lacking is an understanding of why the Waqf law was brought into place in the first place and why the requirement of registration was brought in the first place. You have to understand that there are 3 distinct actors, 3 distinct interests at play in a Waqf. One is that of the worshipper, or in that sense, the beneficiary, if you take the analogy of a trust. So these are the people, in case of a masjid, who are going to the masjid to pray. In case of a dargah, they're the people who are going to pay homage to the saint there. If it's a qabristan, it's the people who are burying their dead in the qabristan. Then there is the mutawalli, who is in the position, to continue that analogy, of the trustee. So in that sense, he is the person who's charged with the responsibility of compliance with legal provisions. And the third actor is the state. Of course, there's also the Waqf board, but by and large, the state actors are the third bucket. Now, as far as the requirement of registration is concerned, the reason why registration was made mandatory was because mutawallis, absent any registration, were treating Waqf properties like their personal properties.
Okay.
And so they had to be forced to register so that there could be some accountability for what were properties that were only entrusted to them. Now, clearly, there is a conflict of interest between the mutawalli and the regulatory framework, because the regulatory framework wants the Waqf property, which is property for the benefit of a section of the public, to be under the regulatory framework and under scrutiny, while the mutawalli wants it away from the regulatory scrutiny, and so that doesn't want to register. And so, this was remedied by first putting in a requirement in the law that the mutawalli had to register, then putting in a penal provision saying a mutawalli who doesn't register will be punished. But like I said, there's a conflict of interest there. Now, thereafter, because mutawallis were still not coming forward and registering, a requirement was brought in that there will be a survey by the state of Waqf properties in the state, and the state will then register the Waqf, the properties which are Awqaf properties, which is found in the state. Therefore, that responsibility then moved also onto the state. Now, today, where we are is that the failure of both of these actors, the mutawallis who want to treat the property as their private property, and state, which was expected to do surveys and register the properties, both have failed in their duty. Now, the 2013 amendment to the 1995 Waqf Act started, if you read the statement of objects and reasons, it starts with saying that that only one state has carried on a survey so far. So from 1995 to 2013, only one state carried on the survey that it was required to carry on. So the state's failure in not conducting surveys, the mutawalli's failure in wanting to treat the property as private properties today is being put at my doorstep as somebody who's the beneficiary of that Waqf property, who's a practicing Muslim, who's a worshipper in that sense. That property will be taken away from me, or I will lose my interest in that property on account of failure of two parties who had conflicting interests in terms of the Waqf itself, and the state which has failed in its constitutional, in its statutory duty. So this reasoning that you've had 103 years, and if you're not registered, too bad. It's actually counterproductive, because as a worshipper, I haven't had any opportunity. That I can't register my Waqf, the temple, the mosque that I go to in my neighborhood, the dargah that I go to in my neighborhood. I don't ask for papers of those institutions. I just go, I offer my prayers, and I come back. So that responsibility is not at my doorstep. So then the failure of that responsibility can't take that property away from the beneficiary of the Waqf.
So how do you see this going forward? So is there any timeline that you're looking at when it comes to the hearing of this matter? What next in this entire situation?
See, as far as we are concerned now, like I said, because the interim order, as far as our interests are concerned, left much to be desired. So our focus is going to be on a hearing on as early and expedited basis as may be possible. So that's going to be our representation to the court at every occasion. However, now it's for the Chief Justice of India to constitute a bench for hearing the matter finally, and to list the matter for hearing. Now, that's not something which is within our control. I mean, we can move an early hearing application. When called upon, we can press for an early hearing, but it's for the court to decide when it wants to constitute a bench and list the matter, put the matter down for hearing. We would want it to be done as soon as possible.
All right. Thank you very much, Mr. Pasha, for speaking to India today on this issue. Thank you.